Citizenship in the United States. Being a citizen is a status that entails specific rights, duties and benefits. Citizenship is understood as a right to have rights, since it serves as a foundation for a bundle of subsequent rights, such as the right to live and work in the United States and to receive federal assistance. There are two primary sources of citizenship: birthright citizenship, in which a person is presumed to be a citizen provided that they are born within the territorial limits of the United States, or other circumstances existing at the time of the birth; and naturalization, a process in which an immigrant applies for citizenship and is accepted. These two pathways to citizenship are specified in the Citizenship Clause of the Constitution's 1868 14th Amendment, which reads, "All persons born and naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." National citizenship signifies membership in the country as a whole. State citizenship, in contrast, signifies a relation between a person and a particular state and has application generally limited to domestic matters. State citizenship may affect tax decisions and eligibility for some state-provided benefits such as higher education and eligibility for state political posts such as U.S. Senator. In Article 1 of the Constitution, the power to establish a uniform rule of naturalization is granted explicitly to Congress. U.S. law permits multiple citizenship. A citizen of another country naturalized as a U.S. citizen may retain the previous citizenship, though they must renounce allegiance to the other country. A U.S. citizen retains U.S. citizenship when becoming the citizen of another country, should that country's laws allow it. Citizenship can be renounced by American citizens who also hold another citizenship via a formal procedure at a U.S. embassy, and it can also be restored. What it means to be a citizen. Rights: freedom to reside and work. United States citizens have the right to reside and work in the United States. Certain non-citizens, such as permanent residents, have similar rights. However, non-citizens, unlike citizens, may have the right taken away. For example, they may be deported if convicted of a serious crime. Freedom to enter and leave the United States. United States citizens have the right to enter and leave the United States freely. Certain non-citizens, such as permanent residents, have similar rights. Unlike permanent residents, U.S. citizens do not have an obligation to maintain residence in the U.S. They can leave for any length of time and return freely at any time. Voting for federal office in all 50 states and the District of Columbia is restricted to citizens only. States are not required to extend the franchise to all citizens. For example, several states bar citizen felons from voting, even after they have completed any custodial sentence. The United States Constitution bars states from restricting citizens from voting on grounds of race, color, previous condition of servitude, sex, failure to pay any tax, or age. Historically, many states and local jurisdictions have allowed non-citizens to vote. However, today this is limited to local elections in very few places. Citizens are not compelled to vote. Freedom to stand for public office. The United States Constitution requires that all members of the United States House of Representatives have been citizens for 7 years, and that all senators have been citizens for 9 years before taking office. Most states have similar requirements. For example, California requires that legislators have been citizens for 3 years, and the governor have been a citizen for 5 years. Upon taking office, the U.S. Constitution requires that one be a natural-born citizen and a U.S. resident for 14 years in order to be President of the United States. The Constitution also stipulates that otherwise eligible citizens must meet certain age requirements for these offices. Duties. Jury duty is only imposed upon citizens. Jury duty may be considered the sole differential obligation between non-citizens and citizens. The federal and state courts uniformly exclude non-citizens from jury pools today, and with the exception of a few states in the past, this has always been the case. Military participation is not currently required in the United States, but a policy of conscription of men has been in place at various times in American history, most recently during the Vietnam War. Currently, the United States Armed Forces are a professional all-volunteer force, although both male U.S. citizens and male non-citizen permanent residents are required to register with the Selective Service System and may be called up in the event of a future draft. Johns Hopkins University political scientist Benjamin Ginsberg writes, "The professional military has limited the need for citizen soldiers." Taxes. In the United States today, everyone except those whose income is derived from tax-exempt revenue is required to file a federal income tax return. American citizens are subject to federal income tax on worldwide income regardless of the country of residence. Benefits. Consular protection outside the United States. While traveling abroad, if a person is arrested or detained by foreign authorities, the person can request to speak to somebody from the U.S. Embassy or consulate. Consular officials can provide resources for Americans incarcerated abroad, such as a list of local attorneys who speak English. The U.S. government may even intervene on the person's behalf. Non-citizen U.S. nationals also have this benefit: increased ability to sponsor relatives living abroad. Several types of immigrant visas require that the person requesting the visa be directly related to a U.S. citizen. Having U.S. citizenship facilitates the granting of IR and F visas to family members. Ability to invest in U.S. real property without triggering FIRPTA. Perhaps the only quantifiable economic benefit of U.S. citizenship. Citizens are not subject to additional withholding tax on income and capital gains derived from U.S. real estate under the Foreign Investment in Real Property Tax Act. Transmission of U.S. citizenship to children born abroad. Generally, children born to two U.S. citizen parents abroad are automatically U.S. citizens at birth. When the parents are one U.S. citizen and one non-U.S. citizen, certain conditions about the U.S. citizen's parents' length of time spent in the U.S. need to be met. See United States nationality law for more details. Non-citizen U.S. nationals also have a similar benefit: protection from deportation. Naturalized U.S. citizens are no longer considered aliens and cannot be placed into deportation proceedings. Other benefits. The USCIS sometimes honors the achievements of naturalized U.S. citizens. The Outstanding American by Choice Award was created by the USCIS to recognize the outstanding achievements of naturalized U.S. citizens, and past recipients include author Elie Wiesel, who won the Nobel Peace Prize, Indra K. Noory, who was CEO of PepsiCo, John Shalikashvili, who was chairman of the Joint Chiefs of Staff, and others. Further, citizenship status can affect which country an athlete can compete as a member of in competitions such as the Olympics. Civic participation. Civic participation is not required in the United States. There is no requirement to attend town meetings, belong to a political party, or vote in elections. However, a benefit of naturalization is the ability to participate fully in the civic life of the country. There is disagreement about whether popular lack of involvement in politics is helpful or harmful. Vanderbilt professor Dana D. Nelson suggests that most Americans merely vote for president every 4 years, and sees this pattern as undemocratic. In her book, bad for democracy. Nelson argues that declining citizen participation in politics is unhealthy for long-term prospects for democracy. However, writers such as Robert D. Kaplan in The Atlantic see benefits to non-involvement. He wrote, "The very indifference of most people allows for a calm and healthy political climate." Kaplan elaborated, "Apathy, after all, often means that the political situation is healthy enough to be ignored. The last thing America needs is more voters, particularly badly educated and alienated ones, with a passion for politics." Quote, he argued that civic participation, in itself, is not always a sufficient condition to bring good outcomes, and pointed to authoritarian societies such as Singapore, which prospered because it had relative safety from corruption, from breach of contract, from property expropriation, and from bureaucratic inefficiency. Dual citizenship. A person who is considered a citizen by more than one nation has dual citizenship. It is possible for a United States citizen to have dual citizenship. This can be achieved in various ways, such as by birth in the United States to a parent, or in certain circumstances even grandparent, who is a citizen of a foreign country, by birth in another country to a parent who is a United States citizen per second, or by having parents who are citizens of different countries. Anyone who becomes a naturalized U.S. citizen is required to renounce any prior allegiance to other countries during the naturalization ceremony. However, this renunciation of allegiance is generally not considered renunciation of citizenship to those countries. Under certain circumstances, there are relevant distinctions between dual citizens who hold a substantial contact with a country, for example by holding a passport or by residing in the country for a certain period of time, and those who do not. For example, under the Heroes Earnings Assistance and Relief Tax Act of 2008, U.S. citizens in general are subject to an expatriation tax if they give up U.S. citizenship, but there are exceptions for those who are either under age 18 and a half upon giving up U.S. citizenship and have lived in the U.S. for less than 10 years in their lives, or who are dual citizens by birth residing in their other country of citizenship at the time of giving up U.S. citizenship and have lived in the U.S. for less than 10 out of the past 15 years. Similarly, the United States considers holders of a foreign passport to have a substantial contact with the country that issued the passport, which may preclude security clearance. U.S. citizens are required by federal law to identify themselves with a U.S. passport, not with any other foreign passport, when entering or leaving the United States. The Supreme Court case of Afroyim v. Rusk declared that a U.S. citizen did not lose his citizenship by voting in an election in a foreign country, or by acquiring foreign citizenship, if they did not intend to lose U.S. citizenship. U.S. citizens who have dual citizenship do not lose the United States citizenship unless they renounce it officially. History of citizenship in the United States. Citizenship began in colonial times as an active relation between people working cooperatively to solve municipal problems and participating actively in democratic decision-making, such as in New England town hall meetings. People met regularly to discuss local affairs and make decisions. These town meetings were described as the earliest form of American democracy, which was vital since citizen participation in public affairs helped keep democracy sturdy, according to Alexis de Tocqueville in 1835. A variety of forces changed this relation during the nation's history. Citizenship became less defined by participation in politics and more defined as a legal relation with accompanying rights and privileges. While the realm of civic participation in the public sphere has shrunk, the citizenship franchise has been expanded to include not just propertied white adult men but black men and adult women. Earlier on, U.S. citizenship was not given to people of Indian or East Asian descent. A.K. Mazumdar was the first person born in the Indian subcontinent to attain U.S. citizenship. Few years earlier, as a result of the 1898 United States v. Wong-Kim-Ark Supreme Court decision, ethnic Chinese born in the United States became citizens. During World War II, due to Japan's heavy involvement as an aggressor, it was decided to restrict many Japanese citizens from applying for U.S. citizenship, while Chinese citizens encountered no trouble because of China's alliance with the United States. The Equal Nationality Act of 1934 was an American law which allowed foreign-born children of American mothers and alien fathers who had entered America before age 18 and lived in America for 5 years to apply for American citizenship for the first time. It also made the naturalization process quicker for American women's alien husbands. This law equalized expatriation, immigration, naturalization, and repatriation between women and men. However, it was not applied retroactively and was modified by later laws, such as the Nationality Act of 1940. Birthright citizenship. U.S. citizenship is usually acquired by birth when a child is born in the territory of the United States. In addition to U.S. states, this includes the District of Columbia, Guam, Puerto Rico, the Northern Mariana Islands and the U.S. Virgin Islands. Citizenship, however, was not specified in the original Constitution. In 1868, the 14th Amendment specifically defined persons who were either born or naturalized in the United States and subject to its jurisdiction as citizens. All babies born in the United States, except those born to enemy aliens in wartime of the children of foreign diplomats, enjoy U.S. citizenship under the Supreme Court's long-standing interpretation of the 14th Amendment. The amendment states, all persons born and naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. There remains dispute as to who is subject to the jurisdiction of the United States at birth. By acts of Congress, every person born in Puerto Rico, the U.S. Virgin Islands, Guam, and the Northern Mariana Islands is a United States citizen by birth. Also, every person born in the former Panama Canal Zone whose father or mother are a citizen is a United States citizen by birth, regardless of where they are born. Children of U.S. citizens are U.S. citizens in most cases. Children born outside the United States with at least one U.S. citizen parent usually have birthright citizenship by parentage, while persons born in the United States are considered to be citizens and can have passports. Children under age 18 are legally considered to be minors and cannot vote or hold office. Upon the event of their 18th birthday, they are considered full citizens, but there is no ceremony acknowledging this relation or any correspondence between the new citizen and the government to this effect. Citizenship is assumed to exist, and the relation is assumed to remain viable until death or until it is renounced or dissolved by some other legal process. Secondary schools teach the basics of citizenship and create informed and responsible citizens who are skilled in the arts of effective deliberation and action. Americans who live in foreign countries and become members of other governments have, in some instances, been stripped of citizenship, although there have been court cases where decisions regarding citizenship have been reversed. Naturalized citizenship. Acts of Congress provide for acquisition of citizenship by persons born abroad. Agency in charge. The agency in charge of admitting new citizens is the United States Citizenship and Immigration Services, commonly abbreviated as USCIS. It is a bureau of the Department of Homeland Security. It offers web-based services. The agency depends on application fees for revenue. In 2009, with a struggling economy, applications were down sharply, and consequently there was much less revenue to upgrade and streamline services. There was speculation that if the administration of President Barack Obama passes immigration reform, then the agency could face a welcome but overwhelming surge of Americans in waiting and longer processing times for citizenship applications. The USCIS has made efforts to digitize records. A USCIS website says the U.S. Citizenship and Immigration Services is committed to offering the best possible service to you, our customer, and which says, with our focus on customer service, we offer you a variety of services both before and after you filed your case. The website allowed applicants to estimate the length of time required to process specific types of cases, to check application status, and to access a customer guide. The USCIS processes cases in the order they received. Pathways to citizenship. People applying to become citizens must satisfy certain requirements. For example, there have been requirements that applicants have been permanent residents for 5 years, be of good moral character, be of sound mind in the judgment of immigration officials, have knowledge of the Constitution, and be able to speak and understand English unless they are elderly or disabled. Applicants must also pass a simple citizenship test. Up until recently, a test published by the Immigration and Naturalization Service asked questions such as, how many stars are there in our flag, and what is the Constitution, and who is the President of the United States today. At one point, the government printing office sold flashcards for $8.50 to help test takers prepare for the test. In 2006, the government replaced the former trivia test with a 10-question oral test designed to shun simple historical facts about America that can be recounted in a few words. For more explanation about the principles of American democracy, such as freedom, one reviewer described the new citizenship test as thoughtful, while some have criticized the new version of the test. Officials counter that the new test is a teachable moment without making it conceptually more difficult, since the list of possible questions and answers, as before, will be publicly available. 6 correct answers constitutes a passing grade. The new test probes for signs that immigrants understand and share American values. Military participation is often a way for immigrant residents to become citizens, since many people seek citizenship for its financial and social benefits. The promise of citizenship can be seen as a means of motivating persons to do dangerous activities such as fight in wars. For example, a 2009 article in the New York Times said that the United States military was recruiting skilled immigrants who are living in this country with temporary visas by promising an opportunity to become citizens in as little as 6 months in exchange for service in Afghanistan and Iraq, where U.S. forces are stretched thin. The option was not open to illegal immigrants. One estimate was that in 2009 the U.S. military had 29,000 foreign-born people currently serving who were not American citizens. Spouses of citizens and non-citizens who served in the military also have less difficulty becoming citizens. One analyst noted that many immigrants, not yet citizens, have volunteered to serve in the United States military forces. Some have been killed and others wounded. Perhaps this can be seen as a cynical attempt to qualify more easily for U. citizenship. But I think that service in the U.S. military has to be taken as a pretty serious commitment to the United States. Immigrant soldiers who fight for the U.S. often have an easier and faster path to citizenship. In 2002, President Bush signed an executive order to eliminate the 3-year waiting period and made service personnel immediately eligible for citizenship. In 2003, Congress voted to cut the waiting period to become a citizen from 3 years down to 1 year for immigrants who had served in the armed forces. In 2003, of 1.4 million service members, 37,000 active duty members were not citizens, and of these, 20% had applied for citizenship. By June 2003, 12 non-citizens had died fighting for the United States in the Iraqi War. The military has had a tradition of filling out its ranks with aliens living in the U.S. Non-citizens fought in World War II. The military has struggled to fill its depleted ranks by recruiting more non-U.S. citizens, but there is considerable anxiety about using foreigners to serve in the U.S. Armed Forces. General Dwight D. Eisenhower was quoted as saying, "When Rome went out and hired mercenary soldiers, Rome fell." Grandparent rule. Section 322 of the INA, added in 1994, enabled children of a U.S. citizen who did not get citizenship at birth to use the physical presence period in the U.S. of a grandparent who was a citizen to qualify for U.S. citizenship. In 2006, there were 4,000 applications of citizenship using the physical presence of grandparents. Israelis comprise 90% of those taking advantage of the clause. Strong demand. According to a senior fellow at the Migration Policy Institute, citizenship is a very, very valuable commodity. However, one study suggested legal residents eligible for citizenship, but who don't apply, tend to have low incomes, do not speak English well, or have low levels of education. There is strong demand for citizenship based on the numbers of applications filed. From 1920 to 1940, the number of immigrants to the United States who became citizens numbered about 200,000 each year. There was a spike after World War II, and then the level reduced to about 150,000 per year until resuming to the 200,000 level beginning about 1980. In the mid-1990s to 2009, the levels rose to about 500,000 per year with considerable variation. In 1996, more than 1 million people became citizens through naturalization. In 1997, there were 1.41 million applications filed. In 2006, 1.38 million. The number of naturalized citizens in the United States rose from 6.5 million in the mid-1990s to 11 million in 2002. By 2003, the pool of immigrants eligible to become naturalized citizens was 8 million, and of these, 2.7 million lived in California. In 2003, the number of new citizens from naturalization was 463,204. In 2007, the number was 702,589. In 2007, 1.38 million people applied for citizenship, creating a backlog. In 2008, applications decreased to 525,786. Naturalization fees were $60 in 1989, $90 in 1991, $95 in 1994, $225 in 1999, $260 in 2002, $320 in 2003, $330 in 2005. Application fees were increased from $330 to $595, and an additional $80 computerized fingerprinting fee was added. The high fees have been criticized as putting up one more wall to citizenship. Increases in fees for citizenship have drawn criticism. Doris Meisner, a senior fellow at the Migration Policy Institute and former Immigration and Naturalization Service Commissioner, doubted that fee increases deter citizenship seekers. In 2009, the number of immigrants applying for citizenship plunged 62%. Reasons cited were the slowing economy and the cost of naturalization. Citizenship ceremonies. The citizenship process has been described as a ritual that is meaningful for many immigrants. Many new citizens are sworn in during 4th of July ceremonies. Most citizenship ceremonies take place at offices of the U.S. Citizenship and Immigration Services. However, one swearing-in ceremony was held at Arlington National Cemetery in Virginia in 2008. The judge who chose this venue explained, "I did it to honor our country's warriors and to give the new citizens a sense for what makes this country great." Quote, according to federal law, citizenship applicants who are also changing their names must appear before a federal judge.